Right. It's still the 19th of May. It's now 4 o'clock in the afternoon. I've been at this for quite some while. And now I'm going to look at part 5 now. This is part 5 of my talk on the history of jurisprudence and democracy. I finished primarily the main theories of jurisprudence to give you a kind of potted history. But I did mention, didn't I, about the Constitution of the United States, the Founding Fathers, and the purposes of laws in order to stop tyranny and so on. Well, I think with the way the world's going, with the number of wars, as I talk now, there's the war in the Middle East, Israel and Palestine, Israel, America and Iran, Israel and Lebanon, and there's conflicts in Africa, the war in Russia and Ukraine. And of course international law is relevant to this, but also so is domestic state law, particularly when it comes to the United States, because the United States would be the forefront of democratic rights and powers. It was the one which, the country that always was the one that would step up and defend democracy. But things have been happening in there. Now, I mentioned to you the British Constitution. The American Constitution was derived largely from British common law, and the object was to have 3 separate entities, each one overlooking the shoulder of the other one, to make sure that there is no tyranny. It becomes more important in a society where one party has the ability to press a nuclear button. And what's happening in America, of course, is the Constitution set up three individual bodies: the executive, Trump, the lawmaker, the Senate and Congress, and the judges, the judiciary, as the 3 limbs. And the Constitution did that to preserve, the democracy of the United States. And we can see currently that's, I'm not just me saying it, but there's law judgments saying that the Constitution is under threat. Now that means that the democracy of the world's largest, most powerful democratic hitherto country is at risk. I have followed the trials and tribulations of judgments made in Maryland and DC, and the comments of the judges there in relation to the attack on the Constitution, and the things that have been going on in Congress and the Senate. But I was wondering how to bring this to a sort of like an academic level and deal with exactly what's actually happening. So we also have to look at what's happening in the United Kingdom in terms of its democracy as well. In terms of the United Kingdom, I have dealt with jury equity in a different talk, and also my view on changes to the criminal justice system. That's another separate playlist, and also the jury system. So I've dealt with a lot of this stuff anyway. But now I'm going to look at the United States, and particularly Mr. Trump and his position, because he's the executive. He's also one of the most powerful men in the world. And that, like the other most powerful men in the world, if there's no rules, either individually in that state or rules in terms of world order, the risk of war is huge, as we can see with the attack against international law by Russia on Ukraine. Well, I'm not going to enter the debate about Israel and Palestine. Suffice it to say that the International Criminal Court is involved, and there are numerous amount of pressure groups from both sides talking about what it constitutes criminal acts and what doesn't. I'm thinking in terms of more world order rather than individual criticism. So where have I started? Well, I find that the case of Trump v. the United States 2024, the Supreme Court, is a good place to start. It is case number 23-939. It was decided on the 1st of July 2024. This is the case where the Supreme Court considers the scope of presidential immunity from criminal prosecution. So this is basically giving the president immunity for anything he does. And I'll explain this in more detail, but I'm going to have to go into the facts of the case. A, it's very interesting because it's contemporary. B, it's no other president has ever been able to challenge the Constitution in this way. And C, it has an impact on the world because of the importance of the United States. From from January 2017 to January 2021, Donald Trump served his first presidency of the United States. On August the 1st, 2023, a grand jury indicted him on 4 counts for conduct that occurred during his previous presidency, following the 2020 election. Effectively, the indictment said that after losing the election, Trump conspired to overturn it by spreading knowingly false claims of fraud to obstruct the collecting, counting, and certifying of those results. And firstly, it said that he and his co-conspirators knowingly used false claims of election fraud to get officials to change votes from Trump's opponent, Joe Biden, to Trump. Secondly, the conspirators organized fraudulent slates of electors in 7 targeted states and caused these fraudulent electors to send their false certificates to the vice president to be counted at the certification proceedings on the 6th of January. The 6th of January, of course, you remember, where there was a number of people convicted for a riot at the seat of democracy in Washington. Thirdly, the conspirators attempted to use the Justice Department to conduct sham election crime investigations and to send a letter to the targeted states falsely claiming the Justice Department had identified significant concerns that may have impacted the election results. Well, the Department of Justice has lost lots of lawyers. Some have been sacked, some have left. Trump has been able to place his own chosen few of people that believe in him into those positions. The Department of Justice has been described as his own law firm. But this sort of allegation, true or not true, is the beginning start of the crack in the Constitution of the United States, in my view. Fourthly, the Trump and his co-conspirators attempted to persuade the vice president to use his ceremonial role on the 6th of January to fraudulently alter the election results. And when that failed, they used false allegations to direct a crowd of supporters to the Capitol and to obstruct the certification process. When the crowd attacked the building, Trump used the disruption to try and convince members of Congress to delay the certification. So those are the brief facts, but they're quite important because these people were convicted of assaults on the Capitol riot, as well as assaults on the police officers, very serious in some cases, and Trump pardoned them all. So the judicial process took place, and he used his royal pardon to do that, because these were supporters of his. And of course, that brings the presidential power of pardons into question. In an earlier talk, I talked about how important it was. I think it's the last part of the talk before this one. I said how important integrity should be brought into play, and you know, I think if integrity is incapable of being naturally produced, I'm afraid we're going to have to find a way of making it part of the process, and that's what I'm suggesting, amongst other things, of course. So Trump decided to try and dismiss the indictment based on presidential immunity. He contended that he has absolute immunity from criminal prosecutions for actions performed within and up to the outer perimeter of his official responsibilities. This was because he said that he could undertake especially sensitive duties with bold and unhesitating action. Emergencies, I suppose. Well, the district court denied that motion. That's the lower court in the state. They did recognise that as far as civil proceedings were concerned, he did have immunity there from damages for liability, but declined to decide whether the indicted conduct involved official acts. So they didn't say what he actually did, whether what he actually did was in fact official acts or not. The court said that the judiciary could oversee the federal criminal prosecution of the former president for his official act, because the fact that the prosecution means that the former president has acted in defiance of Congress's laws. And the district court went on to say that Trump has no structural immunity to the charges in the indictment. Well, this went to the Supreme Court. Now, can we just pause there for a moment? For some reason, the world's greatest democracy allows its politicians to select its Supreme Court judges. It doesn't happen in England, thank goodness. But in America, it means that 6 of the appointees were Republican, or more specifically Trump employees, and 3 were Democrat ones, and that's been reflected in the number of cases, including this one. So this went to the Supreme Court, and the question was whether, and if so, to what extent does a former president enjoy presidential immunity from criminal prosecution for conduct alleged to involve official acts during his tenure in office. This was the first criminal prosecution in United States history of a former president for actions taken during his presidency. The Supreme Court said that in deciding what circumstances should a prosecution proceed, it had to assess the scope of the presidential power under the Constitution. So the Constitution was what it had front and foremost. The court then makes this distinction. It had to distinguish between the issue of the validity of the power, in other words, is it presidential power, and from the cause it's trying to provoke. So, does he have the power? It's different from why he was doing it, or the intention. So the court said that it was satisfied that the nature of presidential power required a president to have some immunity for official acts during his tenure. This was in respect at least to the exercise of core constitutional powers. Core, those are essential constitutional powers, and it must be absolute. So in respect to his essential core powers, that must be absolute. So no question about him not getting immunity, he must have it. For his remaining official actions, the court said he was also entitled to immunity, but that is presumptive. That's presumptive immunity. Now, the Article 2 of the Constitution says this, that the executive power shall be vested in a president. And it goes on further to say, the duties are of unrivaled gravity and breadth. That came from the case of Trump v. Vance in 591 US 786. So his powers are commanding the armed forces, and he removed a lot of the leadership when he came to power the second time, and certainly the legal advisors for the individual heads of the armed forces were removed. He's got the power to grant and reprieves and pardons, and we've seen that in respect of a number of cases, including the riot at the Capitol, where policemen were hurt. He can appoint public ministers, consuls, justices of the Supreme Court, which he has, and officers of the United States. He is able to conduct foreign affairs, foreign relationships, and this is the important point, signing treaties, or I would say going away from treaties, or threatening to move away from treaties. And of course, NATO is one of them. He's also got to ensure that the laws domestically are faithfully followed and executed. And he has responsibilities for the agencies of the executive branch, and can sign and veto bills that Congress passes, and can recommend changes to Congress. Well, he removed the heads of, or people in the FBI, the CIA, Department of Justice, and replaced them with people that are from his base. So that is an undermining of the independent investigative and prosecution branch. That's my view anyway, and that's certainly the view of many. So, what did the Supreme Court decide? Well, the Supreme Court just concluded that the President is immune from criminal prosecution for conduct within his exclusive sphere of constitutional authority, i.e. his central role. However, not all his official acts fall within his conclusive and preclusive authority. There will be express implied sharing authority with Congress on certain areas. His immunity will not extend to conduct in areas where his authority is shared with Congress. The Supreme Court said that the President, within the constitutional scheme, is the only person who composes the branch of government as executive. That's a very powerful position to be in. And in respect of the separation of powers, there's a presumptive immunity from criminal prosecution for his acts within the outer perimeter of his official responsibility. So basically his core responsibilities and his periphery responsibilities, he gets an immunity. So the reasoning behind that is it's meant to safeguard the independence and function of the executive branch. The court said the authority to prosecute the president, the prosecution would have to show that the act complained of proposed no danger of intrusion on the authority and function of the executive branch. So to prosecute him, they'd have to show that the act complained of has nothing to do with his position as the executive. In respect, however, of his unofficial acts, there is no immunity. So the first question in looking at the President of the United States is was he acting in or outside his role? Was it an official or unofficial act? The founding fathers, of course, wanted to encourage vigorous, decisive, speedy execution of the laws by placing in the hands of a single constitutionally indispensable individual the ultimate authority that in respect of other branches the Constitution divides amongst the many. That case is Clinton v. Jones, 520 US 681. The purpose behind that was to ensure good government. For a feeble executive implies a feeble execution of government. So at least when we look back to the Greeks and ancient Greeks, not only did they look to expect a leader to do that, but they actually trained a leader to do that, the qualities that were necessary. And like the presidency of the United States, there is no training. So it seems finally that the Supreme Court says as long as he acts within the constitutional authority, he is safe, even if the objects of his actions are bad. So where does that put the stopping of tyranny, you could ask yourself. There's nothing in the text of the Constitution that supports the decision made by the majority in the Supreme Court. And one can support that by saying that the Founding Fathers could have provided specific immunity, as they did in a narrower sense for the actual legislators, Senate, Congress. That's Article 1, the speech and debate clause. Secondly, at the time of the creation of the Constitution, some states provided express criminal immunity to sitting governors, and the founders chose not to do the same for the president. And thirdly, the founders of the Constitution contemplated some criminal responsibility for former presidents, because the impeachment clause presumes availability of criminal process as a backstop, providing that an official impeached by the state nevertheless be liable and subject to indictment, trial, judgment, punishment according to the law. That clause clearly contemplates that the president could be or should be subject to criminal proceedings for the same conduct that an impeachment follows.